The broadcast is now starting. All attendees are in listen-only mode.
Good morning. I'm Karen McGovern. I'm the Deputy Division Director of Legal Affairs for the Division of Professions and Occupations. I wanted to welcome you and thank you for attending the State Board of Physical Therapy stakeholder meeting via webinar today. Before we get started, I want to introduce the staff members from the Division of Professions and Occupations that are present and who will be helping me facilitate the meeting. So we have Yukon Morford, who is the new program director for the Physical Therapy Board. So would like to welcome him in his new role. As we move forward with today's webinar, I wanted to thank you for your flexibility. As you know, in compliance with the governor's orders regarding the current pandemic, the division has transitioned to a platform that is 100% virtual. So thank you for bearing with us as we make those transitions. I want to reiterate the importance of your comments today. We make decisions every day that affect your life and your business, and your input is vital in the rulemaking process. The goals for today are to clarify and explain legislation, to get your ideas about what would be necessary in the rules to implement the legislation, and keeping in mind that our goal is to ensure minimum competency to enter into the workforce and to provide only that regulation that's absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Today, we're going to be discussing the implementation of House Bill 2013-26, which is called the Red Tape Reduction Act, and it creates an occupational credential portability program. And Colorado Senate Bill 2102, which requires providers to disclose discipline or convictions of sexual offenses. So first, what I will do is go through the bills, and then we can go through the rules and think about what changes might be necessary. Because we're in this virtual space, if you want to make comments, you need to just raise your hand by using the hand icon. Once that I see your hand is raised, then I will unmute you so that you can make comments. Alternatively, for those of you that don't want to speak, you can type your comments into the question box, and then I will read those for the group so that we all have the benefit of everyone's feedback. We have a relatively small group today, so I'm not going to put a time limit on comments, but I would ask that everyone remember that we want to create the space where everyone has the opportunity to provide their opinions and feedback. So I'm just keeping that in mind. Make sure that if you're using audio through your computer that you're muting your phone or turning it on vibrate. And then remember that when I unmute you to speak, to try to keep background noise to a minimum. Sometimes we can get some feedback on this platform. So your cooperation with that is greatly appreciated. I'm going to start out first with Bill 2013, it's House Bill 2013-26. As I said, the short title is Red Tape Reduction Act. The purpose of this legislation is to create an expansion of an individual's ability to practice an occupation in Colorado through this creation of an occupational credential portability program. And essentially what this bill does is it gets rid of the old laws on endorsement and streamlines that. The bill requires that the Division of Professions and Occupations create this program to ensure that if someone who is licensed in another state wants to move into Colorado, so if someone holds a physical therapy or physical therapist assistant license in another state, and they want to move into Colorado, that we're not creating unnecessary burden. The bill requires that the person hold an active, unrestricted license in another state or U.S. territory, that they are in good standing with that license, that they don't have any discipline or criminal convictions that would otherwise violate the Practice Act, and that they demonstrate substantially equivalent experience and credentials. And so that's, I think, what we'll probably be tackling in the rule. The next bill is Senate Bill 2102. This bill requires that all healthcare professionals that are subject to the Health Professional Profile Program, so anyone who has to report under the Michael Skolnick Act, all of those healthcare providers are covered under this statute. And so that does include physical therapists and physical therapist assistants. And what the bill does is that if a licensee or certificant has a criminal conviction for a sexual assault and is serving a sentence with the court, they are required to disclose that conviction and the sentence to their patients prior to providing professional services. The disclosure has to be written. There are some key points that have to be followed, and that will be in the rule that we discuss later. The other piece of the legislation is that if a licensee or certificant has been disciplined on their professional license and they're currently serving a term of probation with the regulatory board, or they have a license restriction or conditions, they must report that to their patients before providing treatment. So that one is kind of a big one with a lot of requirements, and we can look at that specifically when we get to the rule. So before I move forward, does anyone have questions about the legislation? So I'll give you guys a second to raise your hand or type in your questions. And if not, then we'll move on to the rules. Okay, I'm not seeing anything, so I'm scrolling down to the rule where we talk about licensure by endorsement. And here we are. So I've made a couple of red line changes here to the proposed rule. The first thing is just to change the statutory citation. This will now be housed at 1220-2023. I took the part of the paragraph under the purpose and I moved it to its own paragraph 1. Basically, it says to be qualified for licensure, an applicant is required to demonstrate that they hold an active, unrestricted license in another state or territory of the United States and do not currently have revoked, suspended, restricted, or conditional license to practice as a physical therapist. Sorry, that was a tongue twister. Or currently pending disciplinary action against such license in another state or territory. So basically, I added the language that they have to demonstrate that they hold an active, unrestricted license, and otherwise I just moved this language down from the previous paragraph. I added the second paragraph to comply with the new law that says the applicant must demonstrate substantially equivalent experience or credentials. Now, I'm just adding this language because that's the new test, substantially equivalent experience or credentials. Before it was substantially equivalent qualifications. I don't know that the word changes it much, but I think that's something that we need to discuss today. So you can see in the rule that previously the board thought that substantially equivalent qualifications would be graduating from an accredited physical therapy program within the past 2 years and passed the National Physical Therapy Examination. So keep in mind, each one of these paragraphs is one way to demonstrate. They only have to meet one, not all of them. And then B, it says practice in the United States as a licensed physical therapist for at least 2 of the 5 years immediately preceding the date of application. So wondering, sort of as we're looking at this, wanting to get feedback from you all as to what you think about these. Are these too strict? Would you like to see them more broad? Are there other pathways? What are your thoughts? And again, you can use the hand icon to make comments, or you can type into the question box. Okay, well, let me ask you a more specific question. What do you all think about, if you're thinking about demonstrating substantially equivalent experience or credentials, do you think that the option practice in the United States as a licensed physical therapist for at least 2 of the 5 years preceding the date of application, do you think that that is, do you think that that accomplishes the goal of allowing people to endorse in from another state? Do you think it needs to be 2 of the last 5? Could it be 2 of the last 7? You know, what are your thoughts about that? Looks like I do have a question here. So we've got a comment, the more flexibility, the better. What about foreign educated educated physical therapists? We will get to that section. So looking here, okay. So does anybody think that, I got a comment from Lisa Roth, 2 of the last 5 seems fair. The more flexibility, the better. Comment that many PTs are being laid off because of COVID. And so, yes, Eliza Schultz asked if it was actively practicing, and it does. What they're saying here is one pathway is that you've actively practiced in the United States as a licensed physical therapist for at least 2 of the 5 years preceding the date of the application. So just wondering if you guys want to open that up, or I mean, if that seems fair. Then the next bullet, it says if they haven't practiced for at least 2 of the 5 years, then they're required to have passed the NPTE and may demonstrate competency through successful completion of one of the following. So if they haven't practiced with their license, then they would have to go through completing 60 hours of professional development activities. And that's what I'm looking for here is how do we reduce the red tape here? Is it necessary that if somebody holds an active license in another state, they practice physical therapy for 1 year and 7 months out of the last 5 years, then do we say, okay, well, you didn't practice for 2, so you have to complete 60 hours of professional development activities? And I'm asking you sort of as the experts, what do you think is required to demonstrate competency to endorse into Colorado? Eliza Schultz says it may be hard to get professional development activities without having a license. I think that's true. I think there can be some CEs that can be done. It looks like good questions, like to take these questions back to APTA. Got a question about what about a licensed PT working in academic and have not been practicing clinically? I think that's a good idea, a good question. And I pose that to you, is that enough to demonstrate continued competency? And I want this forum to be sort of open discussion so that we can kind of work through some of these things. so that we have a good set of proposed rules to go into rulemaking. And so I think there's this piece here about the continued competency that might be something good to chew on. And they do go through and list a lot of the activities, but to Eliza's point, some of these can't be done without a license. We do have, the board does have this catch-all, which I do like leaving in the rules, which is we'll set out all these pathways, but for someone who is unable to meet these pathways, the board still will look at the application and consider the request on a case-by-case basis if the applicant wants to demonstrate their competency or their substantial equivalence by other means. Does anybody have any heartburn about that, by leaving sort of the catch-all where the board can consider other options that may not be included in the rule? Okay, so Eliza comments that she likes the catch-all because we can anticipate every situation. I do appreciate that. I think that that's why I like to keep the catch-all there, is to provide the flexibility. Emmanuel John comments, that's great to give the board the discretion and thinking out of the box. Okay, agreed. So I'm going to let you guys chew on this for a little bit. I'm just going to look down here at foreign trained and see if I don't see that necessarily 1326 changes the requirements for that, because that wouldn't be licensure by endorsement. But I'm going to go up here to look at the rule. And so this is different than endorsement. So this doesn't fall into the occupational portability. And so we didn't notice this for conversation, but I think it's something that I certainly will pass on to the board if there's some interest in looking at this. How would the board interpret actively practicing versus holding a license? Typically, they require that they provide, I don't know the name of the form, but they require a list of the practice. So what you will typically see on the form is, I worked at, I lost for a name, but, Jones Physical Therapy LLC, I worked as a physical therapist there for 17 months, and they list that on the list. I think that does academic count? I think different boards have different opinions, and that's something that I can certainly put in the comments to talk to the board about. Some boards say that academic practice is not clinical practice, and when they say actively practicing, that what they mean is clinical practice. I don't see that in these rules, and so I'd have to find out how the board thinks about that. The other question was, could a PT have a license in good standing for 23 months, but their license was good for 24 months? I think the issue is that they have to have a license in good standing at the time of application. And then again, if it wasn't in good standing because they had discipline, then that's something that the board will have to look at. Previous discipline is not a barrier. It doesn't, it's not an absolute that you couldn't endorse in, but it is something that could affect your ability to endorse in. When you think about endorsement, it should be this very slick process where you have someone who's licensed in, say, Nebraska, they hold their license, they meet the credential, they turn in their application. It should be a very smooth and swift process then to grant licensure here, as long as they can demonstrate their substantially equivalent experience. So that's sort of what we're looking for in this, in this new bill, is just to create that space where it's just a very quick turnaround to get people into the state. One example that I like to give is for barber and cosmetology, Colorado requires 1,000 hours of education. There's many states that only require 850 hours of education. And so it's making sure that that 850 hours in say, Florida is equivalent to the 1,000 hours in Colorado. And being able to have a program where you determine that up front, so you're not holding up each individual application. And so that's what I would kind of think about when you're thinking about these pathways, right, listed as ABC, is how could a physical therapist demonstrate substantially equivalent experience or credentials if they went to school in another state, if they had their training in another state? What makes their training equivalent to what we require in Colorado? And while you guys think about that, I'm going to move all the way down to Senate Bill 2102 and the rule that is required for that bill. And I'm sorry, I'm on my laptop, so my scrolling is very slow. Okay, here we go. So what this bill requires is that on or after March 1st, 2021, a licensee shall disclose to a patient instances of sexual misconduct, which include a conviction or guilty plea, or a final agency action resulting in probation or limitation of the licensee's ability to practice, as defined in 2030-115. The disclosure has to be written, and it has to include all the information specified in the statute and consistent with the sample model disclosure form. So I'm going to scroll down and show you that we included a model disclosure form. In this disclosure form, we have included everything that the statute requires so that the licensees don't have to keep going back and forth to the statute. They can look at this model disclosure and make sure that they've included everything. They need to, at a minimum, include their name, business address, and telephone number. They need to list the final convictions or guilty pleas to a sex offense. And then they have to provide all of this information: the date of the judgment, the nature of the offense, the type, scope, and duration of the sentence or other penalty, whether they were convicted or they pled guilty, if they were placed on probation, what's the duration and term, and then the jurisdiction that imposed the sentence. And they need to do the same thing if they have any final agency action by a professional regulatory board that results in probationary status or other limitation. And that is if the final agency action is based in whole or in part on either the conviction, or if there's a finding of unprofessional conduct that is grounds for discipline that relates to sexual misconduct. And it does talk about that the conduct has to be related to or include harm. It has to result in harm to the patient or presents a significant risk of public harm. So you can see here, then here's the list of things that have to be disclosed about that action. There's a required signature that has to happen, and so we included a sample signature block that complies with the statute. I'm going to go back up to the rule. I think the important piece to remember about this disclosure is that it has to happen, and I have the next paragraph is the timing. It has to happen before treatment is provided. So the language of the statute says it shall be provided to the patient the same day the patient schedules the service. In those instances where an appointment is scheduled the same day of service, or if an appointment is not necessary, such as if people take walk-ins, the disclosure must be provided in advance of treatment. So then the question comes up is, does it have to be provided before every treatment? And the answer is no. The answer is yes, unless the treatment with a patient occurs in a series over multiple appointments, or a patient schedules follow-up appointments. So if you are seeing someone for therapy and they have 10 therapy appointments, you don't have to make the disclosure every time they come in. You can do it at the beginning of their therapy treatment plan. The caveat to that is if something changes in your disclosure form, then you would have to update it. Then here's the big part to remember is the requirement to disclose is only in place while you are serving probation, or your license is limited, or you're still under the jurisdiction of the court. So once you complete your sentence for the conviction, then you no longer have to make the disclosure to patients. Or once you finish your probation with the board or any regulatory agency, and you've successfully completed that, then you no longer have to make the disclosure. So I think it's important to remember the disclosure only happens while you're serving a sentence or while your license is under probation or other limitation based on sexual misconduct. And then there's a list of exceptions that is going to be helpful, because I'm sure people are asking, what do I do when I'm seeing people in an inpatient facility? So basically, here's the list of exceptions. If the patient is unconscious or otherwise unable to comprehend the disclosure, and a guardian of the patient is unavailable. This is when we talk about unable to comprehend the disclosure, we're talking about because of their mental status, not because they speak another language. They're still going to have to find a way to make that disclosure if English is a second language. If the patient visit occurs in an emergency room, freestanding emergency department, or inpatient facilities where there's no visit scheduled. If the licensee providing professional services to the patient is not known to the patient until immediately prior to the start of the visit. I think this could also cover the inpatient piece, but this serves to cover, if you think about anesthesia, people go into the operating room, they may not know who their surgical assistant or surgical technologist is before they go into the operating room, or they may not, in some cases, know who their anesthesiologist is. So I think that's the catch-all for 3. And then 4, the licensee does not have a direct treatment relationship or have direct contact with the patient. So this applies, if you're working, I would say if you're the PT supervisor and you're not having any direct contact with the patient and you're not involved in their treatment plan, then that disclosure wouldn't have to be made. It also covers our pharmacists who will be filling prescriptions at somewhere in let's just say somewhere in Lone Tree, and the patient picks up their prescription in Thornton, and the pharmacist who is technically treating the patient will never have any contact with the patient. And so that's sort of the catch-all for 4. So that was a huge mouthful. And so I'm wondering what thoughts you guys have on this. Okay, I've got a couple of questions here. What about the inpatient settings, nursing homes that are scheduled appointments? I think that if you're scheduling an appointment with a client, then you should be making the disclosure prior to the appointment. And if you think about the purpose of the bill, or the intent, really, it's to make sure that patients are aware and they have a choice. And I think that some of the conversation was, if you're already in my room, or I'm already in your waiting or your exam room before you tell me, then I wouldn't feel comfortable leaving. But if I knew ahead of time, I would say, no, don't come, or no, I'm not coming. So if that makes sense. Telehealth visits would not be treated differently. Telehealth is a mode of treatment, but is not treated differently in this case, because you still have patient contact. You still have a treatment relationship with the patient, even though you might not be in physical contact with the patient. And then I see that, Eliza, you had a question. It said, what were the results of this conversation with other professions like OTs, chiros, or acupuncturists? Is the division working to align any of these policies? Is each one being treated differently? And I'm wondering if that question was pertaining to 1326 or 2102. Ah, 1326. So 1326, we've had conversations with many of the professions. We have suggestions in that we would like to see them open up, and that's really, we're following the intent of the statute and trying to open things up. We've not met with occupational therapy at this point. And the chiropractors are on about the same schedule that you are. We did talk to acupuncturists. They have a little bit different situation in that, well, maybe it's not different. I shouldn't make that assumption. The acupuncturists are very tied to their national certification as a means for demonstrating competency. And so we're trying to open up a few other paths aside from that for people who may not value that national certification as much as others do. Does that make sense? I think that the division is required to, it's sort of the way the law is written. So the division is required to create this program for credentialing. And then we have to balance that with the fact that all of these boards, when we're talking about the policy autonomous boards, that they have the rulemaking authority. So we try to discuss sort of the intent and all of that, but at the end of the day, the board has the rulemaking authority. So that's sort of the balance that we're trying to strike right now. So obviously they won't all look the same. Okay, does anybody else have any questions, any thoughts? I will say that in talking about Senate Bill 102, or 2102. I've not gotten a ton of feedback from people. I think it's a touchy subject and people don't really want to broach it if it doesn't, because it doesn't impact them directly. But that being said, I'm certainly interested if people don't feel like it's clear or if it could be more clear, what we could add. So certainly welcome to that feedback. Okay. Well, I don't see any more questions. I don't see any hands raised. We will be, as far as next steps, I'm going to turn off my screen share here so I can look at the calendar. I don't want to give you the wrong date. And I only have one screen here. So it looks like the draft rules will be filed on September 15th. They'll be filed with the Secretary of State. And the rulemaking hearing is scheduled for October 15th at 11 a.m. So once we get that filed, we will get out those draft rules to you, and then we will circle back before the rulemaking hearing with another stakeholder meeting to get input and feedback. The rules, the last rule won't look much different, and then the other rule, just as I get more feedback, I'd like to be able to revise that. So if you think of anything that you didn't have today, please feel free to submit those in writing. We take written feedback all the way up to the rulemaking hearing, but it would certainly be appreciated if you had anything, if you could get it to us by the 15th so we could make sure that it's included in the proposed draft rules. You can send your feedback to Dora, DORA _ DPO _ rulemaking at state.co.us. And then we can incorporate that feedback into the proposed rules filed with the Secretary of State. Okay, I don't see any hands. I don't see any further questions. So thank you all for your time. I really appreciate it. Remember to send any feedback that you have, and have a great day. Thanks.